Welcome aboard, applicants. Well, I thought today we would start with the first year law students exam, November 2020, question number 3. As with all of our essay questions, let's begin with the call of that question. Down here it says, number 1, on what theory or theories of liability could Alice reasonably sue manufacturer? Discuss. 2, on what theory or theories could theories of liability could Bill reasonably sue manufacturer? Discuss. So as we start crafting our answer, let's start answering our calls, okay? So we want to first say Alice, because who is suing who? Alice v. manufacturer. Okay, and then coming down here you can say theories of liability could Alice, reasonably sue manufacturer? Okay, and then what theories, question mark, of liability could Alice sue manufacturer, question mark. Now down here underneath call number 2, where we're basically going to do the almost exactly the same thing but swap out the parties. So we'll copy and paste that down here. Okay, instead of Alice it's going to be Bob, and then down here we'll just say Bob. Okay. Oh, excuse me, Bill. Thank you so much. Okie dokie. Make sure you get your parties. Okay, now let's read the question. Manufacturer produces and sells fully assembled bicycles, bikes, directly to consumers. Alice purchased one of manufacturer's commuter bikes, the frames of which was composed of aluminum tubes welded together. Shortly after receiving her bike, Alice was riding it to work when, without warning, the frame collapsed, causing her to crash and suffer serious injuries. Alice took the broken frame to a bike mechanic, who told her that several of the tubes had not been properly welded together. The mechanic told Alice that in my many years of repairing bikes, I have never seen such sloppy welds on this or any other brand of aluminum bikes. Bill purchased one of manufacturer's road racing bikes, the frame of which was composed of a carbon fiber, making it much lighter than if it were made of aluminum. Many of manufacturer's competitors also produce racing bikes with carbon frames. In order to make its racing bikes lighter than any other similar bike on the market, manufacturer reduced the thickness of the carbon tubing by 1 millimeter in comparison to its competitors. Several reviews of manufacturer's bike in bike racing magazines suggested that although the bike was lighter, using less fiber carbon material made the bike less stable, slowing the bike down. According to these reviewers, using less fiber carbon also made the frame considerably weaker and subject to breakage. 6 months later, during a race, the frame on Bill's bike collapsed, causing him to suffer serious injuries. An investigation of the crash reveals that one of the carbon fiber tubes on Bill's bike had cracked and broken in half. Okay, we now know what area of law we're dealing with. We're obviously not dealing with contracts law, and clearly this is not criminal law. This has to be tort. So let's put down our tort shopping list right now so we can, as we start reading it a second time, we'll just put in our shopping list. We got intentional tort, negligence, strict liability, vicarious liability, products liability, and then defamation, invasion of privacy, and remedies. Make sure to copy and paste this down below. First of all, we should also be starting to ask ourselves some of these questions. Are we dealing with an intentional tort? It most likely is not going to be an intentional tort. Are we dealing with defamation or an invasion of privacy issue? Nope, we're not dealing with that either. Are we dealing with a possible vicarious liability, the employer's responsibility for an employee? It doesn't look like it. Are we dealing with any other in between kind of torts like misrepresentation, or are we dealing with something involving immunity or statute of limitations? No, it doesn't seem like that. So we're just going to bring these up now, and we were pretty much, and we're not dealing with misrepresentation, invasion of privacy, nuisance, or interference with contractual advantage. So here we already now have started to build our framework for making our answer up. So we're going to copy and paste this now. Since the fact pattern between Alice and Bill are very similar, we're going to be able to just use the same setup for both. Okay. Now, coming now down, or going back up now, and we're going to issue spot for Alice. Manufacturer produces and sells fully assembled bicycles directly to consumers. This is going to help establish that we're dealing with a product liability. And in terms of product liability, we're going to come down now and we're going to open up our template for that. Okay. But by the way, it won't be strict liability either. I'm glad you spotted that. That's not animals or activities. Okay, we're just dealing with products liability. In terms of products liability, and by the way, probably we will use negligence, but we will use it within products liability. In products liability, we're going to be talking about two particular aspects of product, or three particular aspects of products liability. We're going to talk about negligence. We're going to be talking about strict products liability, or what we might call strict liability and tort. And don't forget about warranty. We're probably going to be implied warranty, because since there wasn't anything mentioned as to express warranties that were in print, obviously that would make them expressed, right? Okay, so now down here, we want to copy and paste this down below. So we're keeping both templates going at the same time and saving time for us as well. Okay, now when we're dealing with negligence, we want to break out our negligence as well. We want to actually, let me come up here and do this up here for you. We have duty, breach of duty, actual cause. Oh, I should spell that. There we go. Proximate cause, damages, and don't forget about the defenses of contributory. Well, remember, when we're dealing with products liability, there would be only two here. It'd be comparative negligence and assumption of the risk. Okay, now be sure to space these out here. Now down underneath strict products liability, we're going to be talking about manufacturer. Then we're doing stream of commerce, defective product, actual cause, which is going to, our analysis, our rule statement up above will also be coming down here. We can super that under actual cause and proximate cause. Damages the same. Now the defenses might be different. Okay. By the way, we want to make sure we use the word header up here. Defenses. Okay. Excellent. Okay. Down here under defenses, we might be bringing up additional issues in terms of that, like third-party alteration, unforeseen plaintiff misuse, state-of-the-art defense, those kinds of things. Okay. Now under applied warranty, we're going to be talking about two particular things in merchantability. And fitness for a particular purpose. Okay, and then remedies, we want to make sure that we bring that up. So it could be that we're dealing with lost wages, lost future earnings, out of pocket expenses, those kind of things. Down here, okay, and now let's, to save our time between, that's why we're doing pre-writing setup right now, which is what we'll also do for Bill down below. There we go. Now we can start coming up to the question and start filling out our template, that is. Now, manufacturer produces and sells a fully assembled bicycles directly to consumers. Right here, this, I tell you what, since we have a great template to put that in, I know where that would go. That would go underneath manufacturer, that we're dealing with a proper party, a proper defendant. Both here for both parties, because both parties bought a bicycle from the manufacturer. Okay, how do we know that? Bill also purchased one of the manufacturer's road racing bikes. Okay. Now, Alice purchased one of manufacturer's commuter bikes. Ah, right here. There we go. That still would go into that area for proper parties, okay? Because now we have a proper plaintiff, and what does it also establishes as well under negligence? Possibly, exactly right. Under our McPherson versus Buick analysis, this would be a foreseeable user of the product. Excellent job. Now, the frame of which was composed of aluminum tubes welded together. Now, that concerns the commuter bike. Okay, this will help establish whether the product itself was defective, and that would go under defective product right here. Which we want to make sure that when we talk about defective product, thank you so much for pointing that out to me. Manufacturing defect, design defect, and inadequate warning. Oops, okay. Make sure I got that spelt right. Now, under manufacturing defect, this is going to be consumer expectation test. There we go. Got that. Oh, thank you. And under design defect, it's also going to be established by the consumer expectation test and risk utility. Risk versus utility. There we go. Okay, we're going to come out here, and we're also going to paste this down underneath bill to save time when we start writing the bill versus manufacturer argument. Here we go, right here. Thank you. Right there. Excellent. Good. Okay. So shortly after receiving her bike, Alice was riding it to work when, without warning, the frame collapsed, causing her to crash and suffer serious injuries. So now what we're looking here, this would also be in terms of the damages. Also, we're looking at whether or not, in terms of the defenses down below, in terms of assumption of the risk, did she assume a risk riding her bike to work? Well, it doesn't seem like that, and without warning, it doesn't say that she assumed any risk either. So we could possibly argue that under assumption of the risk, and under the aspect of damages. Alice took the broken frame to a bike mechanic. Ah, right here. Is this the same person that is this mechanic the manufacturer? No. So we could actually throw in a defense down here of third-party alteration. Okay. Oh, the other thing is, don't forget about this too. Thank you so much for pointing this out with me and staying with me here. This would be unforeseen plaintiff misuse in terms of her riding the bike to work. Okay. Now, up above here, the bike mechanic told her that several of the tubes had not been properly welded together. Okay, that goes to whether or not it was defective. It's defectively made in terms of manufacturing or design. The mechanic told Alice and also too, the inadequate warning. So the mechanic told Alice that in my many years of repairing bikes, I have never seen such sloppy welds on this or any other brand of aluminum bikes. So it could be that this is manufacturing more than design, but it's possible it could be a design. But I would argue all three. You got manufacturing, design, and inadequate warning going on here. Okay. Now underneath, Bill purchasing one of the manufacturer's road racing bikes. Again, we're just filling out Bill's stuff now down below. Here underneath Bill, we got a foreseeable user of the product. We got the correct party, defendant, manufacturer of the product. Number one, to enter the stream of commerce, or number two, enter the stream of commerce, and that we're dealing again with a foreseeable user of the product under the McPherson versus Buick analysis. Okay. Now coming up here, the frame of which was composed of a carbon fiber, making it much lighter than if it were made of aluminum. This goes to aspect about maybe at this point it instead of more of the warning, or excuse me, the warning and manufacturing for Alice, it could very well be design and warning and manufacturing for Bill. Now make sure that we highlight this and we use that fact. Many of manufacturers' competitors also produce racing bikes with carbon frames. Okay, so that's aspect 2 underneath Bill. It's state of the art. Okay, down below, right here. Okay, right here. Excellent. Okay, we'll highlight that. In order to make its racing bikes lighter than any other similar bike on the market, manufacturer reduced the thickness of the carbon tubing by 1 millimeter in comparison to other competitors. So this could very well add to as to not only are we dealing with a manufacturing versus design defect, but down under our negligence, the actual breach of duty argument right here for right up here. Let's see. Okay. Fine. There we go. Thank you so much. Right here in the breach of duty, that would be the risk, the benefit or burden, the benefit utility, the benefit burden, whether the product could have been made safer at a lower cost versus the 1 millimeter, whatever the manufacturer is gaining by reducing the thickness of a 1 millimeter by, which is basically making the racing bikes lighter, is the benefit of making a racing bike lighter. Does that outweigh the 1 millimeter in comparison to its competitors in terms of the carbon tubing? Okay, that's what we need. We need to be taking a look at. Now, underneath several reviews of manufacturers' bike and bike racing magazines suggested that although the bike was lighter, using less fiber carbon material made the bike less stable, slowing the bike down. Again, this adds to that aspect. This up here would be more of the benefit aspect, and this would be more of the risk aspect down here. According to these reviewers, using less carbon fiber carbon material also made the frame considerably weaker and subject to breakage. Again, adding to the fact that this is actually riskier. The risk outweighs the benefit here. Okay. Oh, let me highlight that. Correct. Thank you so much. Now, 6 months later, during a race, the frame on Bill's bike collapsed. Now, causing him to suffer serious injuries. Again, this goes to now that we're dealing with a defective product. This goes to damages, but we're also arguing 6 months later. Is there a possible date issue there? We'll have to come back and take a look at that. Also, is the use of Bill using it as a race? We'll take a look here underneath foreseeable plaintiff misuse here. There we go. Okay. And then whether or not he assumed any risk by knowing that he's riding on a bike that has to be making it lighter would make it more risky that he might fall. Did he assume a risk by racing with that kind of bike? Something to think about. Now, an investigation of the crash revealed that one of the carbon fibers on Bill's bike had cracked and broken in half. Ooh. So that again goes to adding to our aspect about the design defect, possibly maybe the bike could have been made safer by, like we talked about again underneath. Right, I'll show you right here for the risk versus utility for both Alice's situation and especially for Bill's situation. Should the utility, in other words, the benefit of having that particular bike be less in terms of less weight, in other words, or to be better navigatable during the race versus the risk that someone might fall, which it did, and not only did Bill fall, the bike broke completely in half. So I would say at this point that adds 100% under our design defect that we're dealing with a risk that outweighs the utility. And make sure we fill out all of our analysis with the facts we provided above. Make sure we highlight this. Okay, everything looks great. We'll now go down to the second question. This question 3. We're going on to question 4 now. Question 4. Sure, bring this up to the top, or well, actually we'll give this its own page here. Hang with me. Okay, there we go. And remember now, with all of our essay questions, where do we begin? Absolutely correct, with the call of the question. So let's read there. Number 1, buyer claims that the agreement to buy the custom banjo is invalid because it was not in writing. Will buyer prevail on this claim? Discuss. Number 2, buyer claims that the agreement to increase the price from $15,000 to $20,000 was invalid due to a lack of consideration. Will buyer prevail on this claim? Discuss. 3, buyer claims that seller breached the contract because no touring banjo case was delivered as had been done before. Will buyer prevail on this claim? Discuss. 4, if seller prevails, what damages, if any, should he be awarded? Discuss. Again, the names of the parties here should be giving it away. Buyer and seller right down here. We're not dealing with criminal law. We're not dealing with criminal defendant and state. We're not dealing with plaintiff. Well, we are dealing with plaintiff and defendant, but in a different sense. We're not dealing with it in a tort sense here, but in a contract sense. Absolutely correct. Excellent spotting the area of law being contracts law. Okay, now down here, let's put down our contract shopping list. Then we got governing law. We want to make sure that if we're dealing with UCC, that we're dealing with merchants. Then we're down here at valid contract. And we're dealing with possible third-party issues. And then we're dealing whether or not we're dealing with covenants, conditions, excuses, discharge of the duty, breach of contract, and remedies. Okay, now that we've got this hammered out now, let's go up and read our question. Seller is in the business of building and selling musical instruments. Buyer is a recording artist who tours giving concerts for a living. This would help establish that if indeed our contract is governed by the UCC, that both parties are indeed merchants. 10 years ago, seller sold buyer a banjo for $10,000 pursuant to a written contract. Although that contract did not mention a touring banjo case, seller gave one to buyer along with the banjo at no additional cost. Now, 6 months ago, seller and buyer agreed that for $15,000, seller would specially manufacture a custom banjo for buyer with buyer's name engraved on the neck of the banjo. Halfway into the project, seller and buyer agreed to increase the price of the banjo to $20,000 due to an increase in the cost of materials. When buyer delivered the banjo, buyer refused to accept it because seller had not included a touring banjo case. Because buyer's name was engraved on the neck of the banjo, seller could only sell it for $5,000. In addition, seller had to pay $1,000 commission to a musical instrument dealer who found the new purchaser. Seller has now sued buyer for breach of contract. So now we know who's suing who. Seller. So I want to make sure we mark that. Seller v. buyer. Okay, what law are we dealing with here? First of all, let's go up now on issue spot. Now, even though this paragraph deals with a contract, it's dealing with a contract in the sense that it's establishing, basically, if you want to, for lack of a better term, a precedent for a future contract, which is this 6 months ago contract here for $15,000. So we want to make sure, though, we're going to bring down some facts from this paragraph here to help fill out our template concerning governing law. And our governing law, like you've already guessed, is concerning the Uniform Commercial Code because we're dealing with a good. And what would that good be? A custom banjo. Now remember, to specially manufacture a custom banjo, it wasn't that he was paying for the special manufacture of the service. He was paying for the completed product, the custom banjo. So that would be why we would argue Uniform Commercial Code rather than common law. So we come down here, put down Uniform Commercial Code, UCC. We're dealing with a banjo as our good equals good. Okay, and now we're dealing with merchants. We'll come back up here. We'll talk about that. I'm going to say that both parties are merchants because we already talked about that. Seller is a business of building and selling musical instruments. Is that somebody who regularly deals in banjos or has special knowledge or skill relating to a banjo? Banjo being a musical instrument sounds like it to me. So that's a yes for seller being a merchant. Now buyer, who's a recording artist who tours giving concerts for a living, would that party, either regularly deal in banjos or have special skill or knowledge related to banjos? Absolutely correct. Being a recording artist, that's exactly right. So both of these parties are considered merchants. Now, 10 years ago now, this would help establish something later, so we'll have to hold off on that for just a bit. Now, seller and buyer agreed that for $15,000, seller would specially manufacture a custom banjo for buyer and buyer's name engraved on the neck of the banjo. Now, what is this here? What does this go to? This goes to our valid contract, okay? Let's come down here and talk about that. Valid contract contains what? I'll make sure we'll fill this out up here. Governing law. Remember, it's Uniform Commercial Code Article 2, okay? Now, under here, valid contract contains enforceable offer, acceptance, consideration, without applicable defenses against contract formation. Primarily at this it'd be statute of frauds in this contract, okay? And it would be for because we're dealing with a $15,000 banjo, sale of a good $500 or more. Okay, or more. Okay, got it. Now, up here we have an offer. Do we have the quantity? Yes, one banjo with the time for performance, specially manufactured within a reasonable time. Interested party, seller and buyer. Price $15,000. Subject matter, specially manufactured custom banjo. Now, so we have everything required for a offer. And it also looks like there was a meeting of the minds, so we would definitely have mutual assent required for acceptance under UCC to have consideration. $15,000 for banjo for $15,000 appears like the bargain for exchange and consideration is sufficient. Now, was this in writing? Now, if this is where we're ask ourselves, even if it wasn't in writing, is there a way that we can have the exception that would otherwise the statute of frauds would bar enforcement? Would there be an exception to the statute of frauds? Absolutely. It would be this one here. It would be exception, especially manufactured or custom made goods once performance has begun. So okay, now down here, okay, first let's come up here real quick. Right here, where do we find out that halfway into the project, that definitely once performance has begun has been satisfied. We already talked about this. This is our valid contract. Okay, seller and buyer agreed to increase the price. Now this is really tricky here. This because we got now. Okay, now here we go. Seller and buyer agreed to increase the price of the banjo to $20,000 due to an increase in the cost of materials. So we've already gotten through our valid contract argument. Do we have any third-party issues? Obviously not. Do we have any conditions, covenants, or excuses? It doesn't look like there is. Now, under discharge of duty, we'll hold off on that one. But there is, I should say, there in the excuses aspect, we would put in modification, okay? And a modification of the Uniform Commercial Code requires two things: mutual assent and good faith. Okay? Now, when we're dealing with, right up here, when we're dealing with the increased price from $15,000 to $20,000, was there an agreement by both parties for that? Seller and buyer agreed. Yes. So we got mutual assent right here. And the increased price from $15,000 to $20,000 due to the materials, was that in good faith? In other words, increase in cost of materials, was that modification from $15,000 to $20,000 in good faith? It could be argued that yeah, it could be. Okay. So with that, we've taken into consideration that as being underneath our modification argument. Now, when seller delivered the banjo, this also adds to the acceptance aspect that there was actual delivery under the Uniform Commercial Code. Now, buyer refused to accept it because seller had not included a touring banjo case. That goes to something called anticipatory repudiation. And also there's another argument as well. Now, why would before anticipatory repudiation, why would buyer refuse to accept it? Well, buyer refused to accept it because seller had not included a touring banjo case. Like what? All of this information up in here. That 10 years ago, seller had sold buyer a banjo for $10,000 pursuant to a written contract. Although that contract did not mention a touring banjo case, seller gave one to buyer along with the banjo at no additional cost. Well, what would that be? Absolutely be after a modification here, but before anticipatory repudiation, we're going to talk about the parole evidence rule. And that would be whether or not we can bring in this course of performance, course of dealing, and usage of trade. And otherwise, because underneath the four corners approach under the parole evidence rule, prior or contemporaneous, how prior is this? Absolutely correct. It was 10 years ago. So prior or contemporaneous oral or written evidence or agreements cannot be brought into what? Alter a material term of a fully integrated agreement. Okay? And then this would just do that as well. Because we're dealing with a prior agreement. It was most likely going to be it was in writing, and it was being brought in to alter the contract, to materially alter the contract. So we got to make sure, even to mention our general rule, but that we have an exception. That the exception would be argued by whom? Absolutely, it would be argued by buyer. The exception being right here, the course of performance, course of dealing, use of trade, just like we talked about. Okay. All right. Right here now. Make sure we talked about that. Underneath the exceptions, the parole evidence rule. Now, because buyer's name was engraved on the neck of the banjo, seller can only sell it for $5,000. Hang on to that one. We'll come down here. We already talked about now anticipatory repudiation that the buyer could say that there was no perfect tender rule because there wasn't a banjo case with a banjo. Now we're dealing with breach of contract. Oh, excuse me. Let me bring down perfect tender under this one here. If that happens, you guys could just move these things around in your outline. Problem solved. Okay, right there. Excellent. Now, we talked about discharging aspects. Okay, now we're dealing with, we talked about breach. We just finished it right here. Now let's talk about remedies. These would be seller's remedies, okay? Keep that in mind. Or expectation damages. And remember, expectation damages, or sometimes called expectation damages. Then we would talk about for the foreseeability aspect of it, the causation aspect of it, the certainty aspect of it, and whether or not there were unavoidable consequences. But mainly what we're dealing with here is the benefit of the bargain to make the party whole as if the contract were fully performed. And what would that be? That would be the $15,000 if the modification is not effective, and possibly the $20,000 if the modification were effective. Okay. Now under incidental damages, gotta make sure we fill out our template here, up here. Now make sure though we haven't quite got to this 5,000 yet. Okay. Now in addition, seller had to pay a $1,000 commission, $1,000 in commission to a musical instrument dealer who found the new purchaser. This right here would be at the aspect concerning costs related to the breach, which would be incidental damages right here. This would be for the $1,000. And then we have consequential damages right here, which that's, come back up here, consequential foreseeable damages as a result of the breach. Well, that's, you know what, excuse me, let me come back here. Sellers, remember, we need to watch out. Sellers don't get consequential damages. Sellers get what now? Very good spot. Excellent job on that. Lost profit seller. Excellent. And that would be the $5,000 because the seller had to sell it at a loss. Why? Because the buyer's name was engraved on the neck of the banjo. Okay, so that's what he or she would recover under the lost profit seller. Now, We already talked about seller now suing buyer for breach of contract. So we want to make sure now we've dealt with everything. Oh, let me make sure I highlight that correctly. Perfect. Okay, down here. So we've got expectation damages, incidental damages, lost profit seller, and I think that would be okay. I think that's good. Okay, now let's make sure. Okay, expectation damages 15,000, 20,000. We got the incidental damages. We got lost profit seller. Okay, I think that sounds about right. And then okay, I think that's pretty good. We'll come up here. I think we got this. Oh, one extra thing. Just the finding where our calls go in now. Our call number one would go all the way from the start here. This would be call number one, COTQ1. Okay, all the way down to right here. This would be COTQ number two. Call the question COTQ number two. Oh, there it is. And then parole evidence rule would be its own call. Would be our call number three, which is, let's read that real quick. I'll show you. That would be whether or not the contract was breached because no touring banjo case was delivered. And then number four would be what damages should be awarded to seller. Right here, right there, and then COTQ number four. I got that. And make sure at the tail end we want to make sure that yeah, this is perfect here. Okay. I'm really happy with this. Thank you so much for tuning in. Hope you had a great time issue spying these, going through the questions, stretching our essay muscles. Okay, and stay tuned for more battling the big bad baby bar. And thank you so much, and God bless.